Like many other school districts, the Seattle School District allows students to apply to any high school within it. This would work out fine, that is, if schools had infinite space. Not to mention, they have racial quotas to reach, some of which cannot be achieved by just admitting the first students that go through the door. Introducing affirmative action, the system that uses racial profiling to prevent racial profiling. All jokes aside, the intentions are noble. However, this form of affirmative action is not the same one that you and I are used to. Normally, when we think affirmative action, we think of dividing people into groups such as whites, Asians, African Americans, Hispanic, Native American, and so on. However, this system, how it worked, was it divided it between whites and, well, not whites. A non-profit group, Parents Involved in Community Schools, sued the district, arguing that the racial tiebreaker violated the Equal Protection Clause of the 14th Amendment, as well as the Civil Rights Act of 1964 and Washington state law. A federal district court dismissed the suit, upholding the tiebreaker. On appeal, the U.S. Court of Appeals for the Ninth Circuit reversed. Under the Supreme Court's precedents on racial classification in higher education, Grutter v. Bollinger and Gratz v. Bollinger, race-based classifications must be directed towards a compelling government interest and must be narrowly tailored to that interest. Applying these precedents to K-12 education, the Circuit Court found that the tiebreaker scheme was not narrowly tailored. The district then petitioned for an en banc ruling of the panel of 11 Ninth Circuit judges. The en banc panel came to the opposite conclusion and upheld the tiebreaker. The majority ruled that the district had a compelling interest in maintaining racial diversity. Applying a test from Grutter, the Circuit Court also ruled that the tiebreaker plan had been narrowly tailored because 1. The district did not employ quotas, 2. The district had considered race-neutral alternatives, and number 3. The plan had no undue harm to races, and number 4. The plan had an ending point.
District courts granted the school district summary judgment, finding the inter alia that its plan survived strict scrutiny on the federal constitutional plane because it was narrowly tailored to serve a compelling governmental interest.
The issues in this case is whether a school district's decision to admit a student to desegregated high school based on the student's race, in an effort to achieve a racial balance within the school and therefore foster diversity in the educational setting, violates that student's equal protection rights given by the 14th Amendment.
A public school cannot classify students by race and then rely upon that classification in making school assignments.
Though seeking racial diversity is a compelling state interest, the court ultimately ruled that both districts' desegregation assignment plans were narrowly tailored, meaning that the integration assignment plans also invoked racial discrimination rather than their sole purpose of creating racial distinctions for the purposes of integration.
The reason is that it violated the Equal Protection Clause of the 14th Amendment by their use of a student's race in deciding whom to admit to particular public schools.
Now, the vote was 5 votes for PICS and 4 votes against PICS. That's it.
After the verdict was made, Chief Justice Roberts canceled programs in Seattle that had the intention to maintain school-by-school diversity. Justice Kennedy accepted the drawing of school attendance zones and more carefully planned site selection for new schools. Also, he started directing important resources to special programs.